I'd like to take this opportunity to welcome you all to today's webinar. Thank you all for signing up and for taking the time to join us today. We really appreciate it. I'd now like to formally introduce myself. So for those of you that I haven't met, my name's Fiona Brown and I've been the Public Guardian and the Accountant of Court since August 2018. Before we start today's session formally, can I remind you all that today's session is being recorded so that it can be made available to those who could not attend today. I have a fantastic team with me today helping me to deliver the session, who I'll now introduce. We have Susan Miller, Danielle Rose and Amanda Kerr, who will all be presenting today. And behind the scenes we have Lynn Seaton, covering the technical aspects of this virtual session, and Deborah Calderwood, who will be managing any Q&A via the chat function. You will be able to ask any questions in the chat function as we go through the session today. Please make sure when you do so though that you select the all participants option from the drop down so that everyone can see your question and the answer that's offered. We'll also have some time at the end for live questions after the presentation is concluded. In the WebEx function though, the settings are configured in such a way that you're all muted with no camera function at the moment, but when we get to the Q&A session at the end, we can ask you to unmute, we can unmute you all and you'll get to ask your question. So you may be wondering why we've decided to run this session today. So in the Office of the Public Guardian, or OPG as we refer to ourselves, we've always valued the outreach work which we do. This work's reduced since COVID, but we're now building this back up again. So we're focusing on the financial sector on this occasion, and that's as a result of some feedback received from that area and from customers and from colleagues in other jurisdictions. So today's session is around the Office of the Public Guardian role as defined in the Adults with Incapacity Scotland Act 2000 and the way in which our processes and documentation can have an impact on customers and stakeholders, with you, the financial sector, being one of those key stakeholders. We will also highlight some key differences in this field across the jurisdictions within the UK. We hope to increase awareness of our role in Scotland, to see what we can do to assist you moving forward, to discuss recent and pending changes in technology and the pending reform of our legislation. So we hope that this will be the first in a series of sessions with follow-up sessions on specific topics following your feedback today on what you wish to hear more about. Next slide please, Lynn. This slide covers the main topics that we'll discuss today. So who we are and what we do. We'll discuss continuing powers of attorney. And continuing is a term used for the financial aspect of the powers in a power of attorney case, dealing with the money and the property of that grantor. We'll look at the certificates of appointment. We will cover our investigations remit. So this is where we investigate where financial abuse is suspected. We'll propose how we might better work together with you moving forward, and we'll also advise you of what is on the horizon for us digitally and legislatively. Next slide please, Lynn. So OPG is part of Scottish Courts and Tribunals Service. We're based in Falkirk, which is in central Scotland, but we have a national remit covering the whole of Scotland. We have around 110 permanent staff at the moment in a variety of roles, and we get our main remit and responsibilities from the Adults with Incapacity Scotland Act 2000, which is quite a mouthful, so I'll now simply refer to that as the Act moving forward. But we do also have some other responsibilities under adult support and protection legislation too. Next slide please, Lynn. So as I've indicated, we get our main locus from the Act, but we primarily have a financial focus, helping people who have money or property in Scotland, and the welfare aspects of any case is supervised by the local authorities in Scotland. Under the Act, an adult is someone who is 16 years old or above, and we assist where an adult has drafted a power of attorney as a forward planning piece, but we're also involved when the adult is someone with impaired mental capacity who is either living in Scotland or has movable or heritable estate in Scotland. We work alongside their legal proxy, and there are 4 main types of legal appointment or order under the Act, and that's power of attorney, guardianship, intervention order, and access to funds. I won't go into detail on each now, as my colleagues will cover this later on in today's session. Next slide please, Lynn. So what we do, so we have a number of main functions and responsibilities, but we have a general function to register all orders and appointments made under the Act and to maintain what's called a public register of those. So all powers of attorney, guardianship, intervention order and access to funds granted are all registered on the system and searchable by members of the public upon making an inquiry with the office. We also supervise those individuals who have been appointed to manage the financial and property affairs of an adult who lacks capacity to do so for themselves. So we monitor those appointed as withdrawers in access to funds cases and interveners in intervention order cases. We also supervise those legal proxies appointed as financial guardian, and we do all this by, for example, calling for and auditing annual accounts, by considering and processing applications for consent to spend larger sums, or to buy or to sell heritable property, or also to make gifts. There's a variety of ways that we carry out our supervisory function. We also investigate circumstances made known to us where the property or finances belonging to an incapable adult appear to be at risk, and that's across all 4 main types of adults with incapacity case. But Amanda will tell you more about this later. Please be aware, though, that OPG does not have a locus to get involved at the application stage, when a customer is drafting a deed or an application, or where the court is considering the matter before making an order. We get involved when the order has already been made or the deed has already been drafted. And as I said, we primarily have that financial focus moving forward, which we will thoroughly explain as we go through today's session. So with those introductions out of the way, I will now hand over to Susan, who's going to tell you all a little bit more about power of attorney. So next slide, please, for Susan. Thanks, Lynn.
Thanks very much, Fiona. Good morning, everyone. I'm now going to talk you through continuing power of attorney. So when we refer to a continuing power of attorney, we're talking about a financial power of attorney that is registered under the Adults with Incapacity Act, which I'll now refer to as the AWI. So a continuing power of attorney is a document granted by an individual, known as the grantor, while they still have capacity to make this decision. So they can grant powers to deal with property and financial affairs. A continuing power of attorney can begin as soon as it is registered or at a later date and continue through into incapacity. You should check the power of attorney document, as the grantor may have specified when the attorney can start to act. As a continuing power of attorney are tailored to individuals, you'll need to check the power of attorney document to check the individual powers that have been granted. You should, however, remember to check your organisation's procedures. So the grantor can appoint who they wish to be their continuing attorney, and this should be someone that they trust. They can appoint an individual, so one attorney, or more, as well as substitute attorneys. If more than one attorney is appointed, they are referred to as joint attorneys. So joint attorneys may make decisions together and or separately. However, the power of attorney document should be checked to see if it lays out any specific provision on how the attorneys are to act. Sometimes the power of attorney document is sparse in the detail on the way joint attorneys are to act, and this has caused a great deal of difficulty for a number of attorneys, as some financial institutions stop recognising the power of attorney as one attorney is no longer able to act. So OPG have recently published a document dealing how we will interpret the appointment of joint attorneys, where the deed fails to clarify. So OPG felt that this was necessary in order to support the original intention of the grantor putting in place the power of attorney. It is our interpretation that the deed would remain active and the attorney remaining to be able to act, unless the document expressly prohibits this. Power of attorneys made under the terms of AWI Act must be registered with the OPG before they can be used. Each power of attorney is read and checked against registration criteria. Once registered, that power of attorney can be used unless the grantor has specified a trigger that needs to be satisfied before the document can be used. For example, they may have specified that a doctor has to certify that they have lost capacity before it can be used. The document would need to be checked for such a power. It is not a requirement of the AWI that an attorney has to provide evidence of the grantor's lost capacity before they can act, unless it is written into the deed. So our weekly processing times are published on our website and Xfeed. Due to the demand for power of attorney registration, it takes a number of months to be processed. However, we do operate an expedited service where there is a genuine need for a power of attorney to be registered. These expedited POAs are processed within 5 working days. Next slide, please. So a power of attorney can be submitted for registration electronically via our ePOR site or by post. The submission process determines what certificate of registration is issued. All postal submissions used to be issued a certificate of registration with a red seal, which I'm sure you're all familiar with. However, from the 1st of July 2023, we stopped issuing the red seal in order to make all our certificates more uniform. So the postal certificates do not need to be certified after they've been issued, and our new certificate clearly advises of this. Electronic ePOR certificates do need additional certification, and again the certificate clearly indicates this. The certification does not need to be done by a solicitor. It can be certified by the grantor of the power of attorney, a solicitor, a stockbroker, or a person authorised for this purpose under the Legal Services Act 2007. So the reason that an ePOR certificate needs to be certified is because OPG staff have not had sight of the original document as it was sent electronically. The postal power of attorney is the original document that has been into this office and checked by OPG staff and therefore authenticated by the public guardian as per section 19.4 of the AWI legislation. So it does not need additional certification. Please note that certificates with the red seal that are still in circulation continue to be valid forms of legal authority. So V codes or validation codes are not generated for power of attorneys registered in Scotland. V codes are currently only provided for power of attorneys registered in England and Wales. We are currently updating our case management system and we do intend to include this feature. However, we have no timescales on this, and we will provide clear communication when these are introduced. We do, however, provide a public register search function. Public register searches can be requested during normal office hours, and the request can be made by completing our public register search request form that is available on our website. A public register search may take up to 5 working days. It can sometimes take a bit longer, just depending on other priorities. So the information available through a public register search, we will provide the public guardian's reference number, the type of order granted, so power of attorney, guardianship, intervention order or access to funds. It will clarify the type of powers granted, financial, welfare or both. It will confirm the date of registration, the name of the grantor or the adult and their status, the name of those appointed and their status. It will also confirm if the order is closed or currently active, the status of all appointed. Sorry, I'm repeating myself there. Again, if it is closed or active. Next slide, please. So on this slide, it's an example of the certificate of registration embossed with the red seal. As mentioned previously, these were issued for all postal submissions prior to the 1st of July 2023 and remain a valid form of legal authority, and these must be accepted by organisations. Next slide, please. So this slide illustrates our current power of attorney certificates of registration for electronic submissions and postal submissions. The crest watermark is now issued for postal and electronic registrations. And you can see our website for more information and to keep your knowledge up to date. We have a section that provides guidance to professionals post-registration. Next slide, please. This slide illustrates the differences and the similarities over the two jurisdictions. So as you can see, in Scotland, We work under the Adults with Incapacity Scotland Act 2000. England and Wales work under the Mental Capacity Act 2005. So in Scotland, each power of attorney will be tailored to the needs of the grantor. In England and Wales, the power of attorney is a templated document. So in Scotland, an attorney must be 16 or older. In England and Wales, an attorney must be 18 or older. And again, validation codes are not provided currently for power of attorneys in Scotland. These are provided for England and Wales only. However, a similarity, a continuing or financial power of attorney can be used when the grantor has mental capacity and continue, or at a later date and continue through to the loss of capacity. And this is the same in England and Wales, as long as the donor consents. We have noted over time that these differences cause a great deal of confusion and frustration with lay people and professionals alike. We are regularly advised of difficulties that are experienced when attorneys are attempting to utilise the powers within a power of attorney document. Next slide, please. Currently, the main difficulties in relation to power of attorney appear to be that banking, DWP and other financial organisations requesting power of attorney validation codes. Special measure certificates that were introduced due to COVID are not being accepted as they have no red seal or they're not the original copy. Similarly, for EPOR certificates, these are not accepted as they have no red seal, they're not the original copy, or they are deemed not to have been certified correctly because it's not been done by a solicitor when it has been correctly certified by the grantor. There are also issues with joint attorneys not being able to act individually. And it is evident that banking staff seem reticent to reach out to the OPG for guidance, and we would really like to point out that we are more than happy to talk to frontline staff as and when required. So thank you, and I'll now hand you over to Danny, who will be discussing guardianship, access to funds and intervention orders. Thank you.
Next slide, please. Thank you, Susan. As Fiona advised earlier, our office facilitates four main provisions. As we've explained, power of attorneys are drawn up whilst a person has capacity. Unfortunately, in certain cases, an adult loses capacity before they have the opportunity to appoint a legal representative to deal with their welfare and/or financial decisions. There may also be adults who have, through a disability, never deemed to have capacity under the current legislation. In these cases, a representative may need to be appointed by the court to act on their behalf. I am currently responsible for the department that registers and supervises guardianship and intervention orders. Intervention orders are a court appointment that allows an intervener to carry out limited duties that have a finite end, such as ending a tenancy or closing a bank account. There should not be any ongoing powers included in these applications, and if there is a requirement for such powers, this is when the guardianship route should be pursued. Guardianship orders are a court appointment where decisions need to be taken for an adult that have an ongoing basis, such as operating bank accounts or making welfare decisions. The normal appointment period is 3 years. When joint financial guardians are appointed, the Adults in Capacity Act is clear that they are appointed on a jointly and severally basis. Therefore, it does not need to explicitly say this in the court interlocutor. It is part of their legal authority. When a guardianship has been granted, this office issues a certificate of appointment, which is a watermarked document that contains the interlocutor issued by the court, that contains the powers that the guardian or guardians have been given. These certificates do not need to be certified, as the court interlocutor is sent to us electronically from the Sheriff Court and is authenticated in line with SSI 2016 number 306 of the Act of Sedgwick. Thus, it should be treated as an original, not a copy. As we've touched on earlier, OPG England and Wales have a validation code that can be used online to check that the paperwork that they have in front of them is registered with their office. At this time, OPG Scotland do not have this facility. We're currently working on a new case management system, and we will endeavour to include such a tool in the future. However, in the meantime, should you or your colleagues have a concern please contact our office and we will conduct a public register search on your behalf. Next slide, please. Okay, so differences is in authority. There's some fundamental differences between POAs and guardianships, as you can see from the slide. POAs are made whilst the grantor has capacity and they control over the powers granted and who should act on their behalf should they lose capacity, and this is contained within the POA deed. Once the grantor has drawn up the deed and had the necessary statutory certificates completed, they will send this to our office where all mandatory checks will be completed, and if found to meet requirements, the deed will be registered and our office will issue a certificate and update our public register. There's no verification code at this time, however you are able to contact our office to ask for a search, and this will be done on your behalf. The OPG do not have routine supervisory powers over attorneys. However, should a valid concern in relation to the actions in financial matters, then we have provisions under the AWI Act to investigate, and my colleague Amanda will cover this in the following section. A guardianship or intervention order is applied for once an adult loses capacity and don't have any other form of intervention in place to manage their welfare or financial interests. Guardianship and intervention orders are court applications which are normally prepared by a solicitor. However, lay persons can do so. This application contains details of who wishes to act and the powers required. The difference to POAs is that the adult does not choose who acts on their behalf and have not had prior conversations on their past wishes. Once the application has been lodged with the Sheriff Court, a hearing will be held, and at this time it will be determined if the order is needed, and if so, the Sheriff, who is the equivalent of a court judge in England and Wales, will make a decision to appoint the guardian or intervener. The OPG are then notified of the appointment and we will issue a certificate with the court interlocutor. This allows the guardian or intervener to begin acting for the adult. As with POAs, we have no verification code. However, we encourage financial organisations to contact us if they wish to check the validity of the appointment. You can find out more information on our website. Unlike POAs, the OPG have an obligation under the AWI Act to supervise the financial actings of a guardian, and this is in the format of a yearly account. Guardian will need to complete a standardised form that shows the income and expenditure for the year and provide supporting documentation such as bank statements and vouching. Should financial harm be suspected by our office or a third party, my team will begin an investigation and on cause shown will take steps to safeguard the adult's estate in the form of freezing the adult's bank accounts and income sources and potentially remitting the case back to court to have the guardians removed. Next slide, please. Thank you. Sorry, bear with me. Certificates. As you can see on this slide, we have sample certificates that are issued when a guardianship or intervention order has been granted. It details the guardian's name and address, the date of appointment, and who they are guardian for. Contained behind this is the interlocutor that's been issued by the Sheriff Court. This details the aforementioned and what powers have been granted and how long the order is for. Once the interlocutor has been received, our office will register the case and issue these certificates to the guardian or guardians. I draw your attention to the footer. It directs that this certificate and the following pages of the court interlocutor do not need to be certified. This is because, as Susan has raised earlier, they are an original. Next slide, please. Okay. Access to funds. Is it suitable? So our last provision, as we've touched on earlier, is access to funds. So what is it? It is an administrative appointment granted by the Public Guardian's Office in cases where an adult has lost capacity and they require assistance with financial decisions in estates that are deemed simplistic, therefore have no heirs property or investments. There is no upper threshold of how much money is held in the accounts. The purpose of these directions is to set up specific instructions with financial organisations to pay for day-to-day expenses such as food or household costs. Applicants can also ask for lump sums to be released to pay for debts, or for much larger purchases. Who can apply for this? This is open and can be an individual, an organisation or a local authority. However, organisations registered as a care establishment cannot apply. However, they have provisions under Section 4 of the AWI Act if needed. Next slide, please. Thank you. So we've just discussed what is an ATF. So it's to cover day-to-day expenses. Adult needs an account in their own name. It can be a relative organisation who can apply. It needs to be fit for purpose, and the application is made by the public guardian. So that's the difference with a guardianship and an intervention order. They are done by the court. Access to funds are done by the public guardian. Next slide, please. Okay, as you can see from the slide, we have a sample certificate that is issued in access to fund cases. This certificate is very detailed and very specific. It gives instructions to financial organisations on what actions that the withdrawer is allowed to take. It also details clauses that the withdrawer and the financial organisation should adhere to. As I have stated, the directions on the certificate are very specific. However, we have seen on occasions that withdrawers are given access above those contained within the certificate. So we would like to make you aware of this so that the accesses out with the withdrawer's remit is not given, as they have no legal authority other than that stated in the certificate. As with our other provisions, there is no validation code. Yet, for those, however, please contact our office if you are presented with a certificate and are unsure of your obligations. Please be aware that we intend to run a webinar dedicated to ATF in the future, and that should help increase our stakeholders' knowledge. I'd like to now pass you over to my colleague Amanda Kerr, who will cover financial harm and working together. Thank you.
Thanks, Danny. So I've got some slides. I'm going to talk about the investigation remits, and then I'm going to move on to the next section, which is working together. So first of all, talking about investigations, if I could have the next slide, please, Lynn. So the Adults with Incapacity Act gives the public guardian certain powers to investigate or take steps to safeguard the finances or the property belonging to an incapable adult where they appear to be at risk. And we can investigate where there is an incapable adult and there's medical evidence supporting that the adult is incapable in relation to the concern. And we're talking about where the concern is in relation to the property and the financial affairs of the adult and where they appear to be at risk. When we talk about risk, we're talking about a current or future risk. The public guardian doesn't have a remit to investigate historical matters. So we're talking about current and future risk. And when it comes to investigations, the public guardian is there to protect the interests of the adult and is not there to represent any other person or any other public body. Next slide, please, Lynn. So when can we investigate? There's two main routes to an investigation. We can investigate where a complaint has been made about how a proxy is using their powers in relation to the property or the financial affairs of an incapable adult. So, for example, that could be a continuing attorney and how they're maybe using their authority. And the second occasion there is we can investigate any other circumstances made known to us where the property or financial affairs of the incapable adult appear to be at risk. So, for example, there could be a third party involved who doesn't necessarily have any legal authority to manage the financial affairs, and there could be a concern around that. So basically that section there is a catch-all. There doesn't need to be anything registered with the Public Guardian's Office for the Public Guardian to investigate. So moving on to the next slide, there's a few areas where we can't get involved in an investigation. So I'm just going to work through this list. So we can't investigate concerns retrospectively in respect of a deceased adult. So unless there is an adult with incapacity, we don't have any legal power to investigate. In relation to joint attorney cases, most joint attorneys have powers and they can act individually. They can act individually to safeguard, promote or to manage the adult's affairs. and because of that, we wouldn't typically get involved in an investigation. However, we are reviewing that position just now, and once we come to a decision regarding that and our involvement, we will make that available. So please keep in touch with us in relation to that. And the third point down there is the public guardian needs to remain impartial in relation to the statutory functions. So we can't get involved in mediation and to mediate between family disputes or business disputes. However, we can review matters factually in relation to the adult to ensure that interests are represented. And the next point there is in relation to capable adults. Our legal authority is derived from the Adults with Incapacity Act, and it really outlines two fundamental elements, one being who an adult is and the other is incapacity. So unless there is an incapable adult, we wouldn't have the authority to investigate those circumstances. There may be a situation where an adult is capable but vulnerable, and if that is the case, that particular situation would be investigated by the local authority, usually in the area where the adult lives. So we would only be involved where there is an incapable adult. And the final point there is the public guardian doesn't have legislative powers to recover funds which have been identified as either misused or abused. We can't recover those funds. So what we would suggest is, and we would always encourage, if you have a concern, is to make an early referral, because as soon as we can get involved in a case, we can start an investigation and we can put any necessary safeguards in place where appropriate. So moving on to the next slide. We've outlined the investigation process to give you a wee bit more insight to what's involved and how you could potentially use that process. And if you are looking for an investigation, the route to that is by completing a referral form, and the referral form is available from the website, and anyone can make a referral to the Public Guardian's office. So that could be a family member, could be a friend, a carer, it could be come from yourselves in the financial sector, may come from the police, social work, etc. So anyone can make a referral, and you would do that by completing the referral form. And we're looking for information from you to get started. So we're looking for information about the adult. We need their name, their address, their current address. We're looking for information in relation to the person who looks after the adults. That would be the medical practitioner, where that's available. And we're also looking for details of the concern, who's causing the concern and what is actually happening. And we're looking for some supporting information as well, if that's available. So all that information goes into the referral form, it comes to us, and when we receive that, our first port of call will be to seek a medical view. And what we're doing is we're getting in touch with the adult's medical practitioner to ask them to come to a view. Does the adult have capacity, or are they incapable in relation to managing or doing something about the concern? And if we have confirmation then that the adult is indeed incapable or lacks capacity to manage the concern, it allows us then to start the investigation. So when we do start an investigation, we will then notify the Adult Support Protection Team at the local authority. So we're keeping them informed of the process. We then will start to gather information, and we do that by contacting relevant people. We're looking to gather information. So we're looking for bank statements, financial records, we'll be reviewing receipts, medical opinion, legal documents, etc., etc. We may also carry out some interviews as well with the relevant people to gather some more information. So once all the information has been compiled and reviewed, we'll come to a view. So the view is the adult's estate at risk? Is there a risk, or is there no risk? And very much depending on the situation, will depend on what safeguards, if any, we can put in place. So safeguards really will depend on the circumstances, what we need to put in place or what action we can take. And in some cases, it may be as simple as offering attorneys maybe advice, some guidance, or perhaps signposting them to the relevant place. We may get in touch with a bank or the building society to ask for the adult's account to be frozen and for the income to be suspended so that it can be redirected at some point for the benefit of the adult. If there's an indication of fraud, the public guardian may refer the matter to the police. And depending on the situation, another course of action might be either for us to recommend that an appropriate body or an appropriate person makes an application, perhaps to access the funds belonging to the adult under Part 3, which Danny spoke about, or perhaps to encourage someone to apply for financial guardianship. So there's various different safeguards that can be put in place. Another group of safeguards could be that we either make an application or we encourage another body, another person to make an application to the Sheriff Court to ask the Sheriff to have an attorney supervised by the public guardian, or perhaps for them to submit accounts to the public guardian so that they can be audited. And in some cases, it may be that we're asking for some powers to be removed from an attorney, or perhaps to remove the appointment, to revoke the appointment. So very much it will depend on the circumstances of each and every case as to what action we'll take or which safeguards we need to put in place, what is appropriate. And I think the important point to highlight again is the public guardian doesn't have those powers of recovery. So if those funds have been identified as being lost due to misuse or abuse, we can't recover those funds. So we really do encourage an early referral, because as soon as we can get involved in the process, we can investigate and put the necessary safeguards in place. So hopefully that gives you an overview of the investigation function and maybe how you would interact with us at certain stages, because we could be right and looking for statements or looking for evidence or looking for a stop to be put on a bank account. So that's a whistle-stop tour of the investigation process. So I'm going to move on to the next slide and the next section in relation to working together. So we all seem to be working with the same customer. We have the same customer in common, and I do wonder if we can streamline what we do and how we work together, if we can streamline that a little bit more for the customer's benefit. And what would really help us would be to have the contact details for the right people in your organisation. So we're looking for email addresses for the right people, or whether it's a central mailbox for general correspondence. Who should we be contacting if we want to keep you up to date about changes? For example, I was speaking earlier on about the joint attorney position and investigations. Who should we notify about those particular changes, about changes in certificates, etc., etc.? And who should we be notifying if we have complex cases or there's a case-specific issue? Are there key people within your organisation that we should be getting in touch with? Can you provide us with those contact details, please? And similarly, at the Office of the Public Guardian, we're also here to support you. So if you have inquiries in relation to certificates, or you have a case and you want to discuss any matter of that with us, please get in contact with us. The contact details for all of the operational teams are available from the website. If you're looking for a named person, please email me. I think most people on the call today will have my email address. from the original comms and the original contact. So don't hesitate to get in touch with me if you're looking for a names person, and I'll try and get that for you. So in relation to resources, we have put together a series of information leaflets which have been designed specifically for financial sector staff. These are now available from the website, and there's a little news item that was published yesterday which has links to each of the leaflets. So there's one there covering powers of attorney, one for access to funds, one for guardianship orders, and one for investigation, the investigation remit. I appreciate we've shared an awful lot of information with you on the call today, so hopefully that the recording of today's webinar and those particular leaflets will go some way to help refresh your memory or give you a source of reference. And the last point there is the future webinars. We're hoping to run a series of webinars, and we're hoping that you'll come back on and join us, where we look at each of the topics in a bit more detail. And we hope that you can join us for those webinars in the future. And that's all I'm going to cover in the session today, and I am going to hand over to Fiona, who's going to talk a wee bit more about what's on the horizon. Thank you.
Thank you, Amanda. Yes, so if we can have, we've got the next slide, thanks Lynn. So I'm going to tell you a little bit more about what's on the horizon for us here at OPG Scotland at the moment, and some of which may impact on yourselves and your day-to-day functions. So there has been of late, and there will continue to be, a significant investment on the digital front. So this will see us replace a 23-year-old case management system with a new product which is currently being built on Microsoft Dynamics. The first launch of this new case management system will be August this year, where our power of attorney products will move over and go live. Over the course of the next year, up to August 25, we will see our other workflows move over and our old system being decommissioned. You've heard us talk about the public register today. Now, our aim is to make the public register publicly facing and accessible to you all. And also by August 25, there should be a portal which you can access yourselves to access and carry out those important public register searches yourself. The new case management system, which we've named Page, will allow us to improve system response times, system stability, security, and all of which will lead to improved processing times. The new platform will then allow us to develop customer-facing enhancements, such as self-service portals to make minor changes, an updated power of attorney submissions portal, and also to introduce verification codes, like we've heard about today, and a whole host of other customer-facing enhancements. It will also allow us to adapt our processes and workflows to take account of any changes made as a result of legislative reform. So it's a very exciting time on the digital front for us. In terms of legislative reform, excuse me, you may know that Scottish Government have given an undertaking to reform all legislation relating to mental health. This includes our Adults with Incapacity Act. We expect a consultation over the summer months this year, and we're already aware that adults with incapacity has been given a priority by Scottish Government. So please do keep an eye on our website and X feed for any updates in respect of reform. Moving on, I'm also delighted to advise you all that we've been working very closely with our colleagues in England and Wales, Northern Ireland and the Republic of Ireland to improve service delivery across border. This should assist in clarifying roles and processes, advertising changes that impact on our customers, finding solutions to common issues, and you may also see a joint session being delivered to you all as a result of that in the near future. On a similar vein, it's OPG Scotland's turn to host the 4 Jurisdiction Adult with Incapacity Conference, which will be held in Edinburgh this November. This again is another opportunity for us to get together across jurisdictions to physically discuss and share best practice and some of those common issues. So next slide, please, Lynn. So this is the final slide, you'll be pleased to hear. We've now concluded our presentation, but we do have some time to take live questions. I think we've got about 10 minutes or so left on the session today. So whilst Deborah's been very busy answering some of the points you've raised in the chat, we can also share share with you a transcript of these at a later stage. But if you do wish to ask a question now, can you please raise your virtual hand, and Lynn will unmute you and call on you one at a time to ask your question. If you haven't entered your name when logging on today, you will get a prompt on the screen asking you to unmute yourself when it's your time to ask a question. So I'll just open the floor to you all now then. Please, if you want to raise your virtual hand, we'll just give Lynn a second or two just to unmute those that wish to ask a question.
Alexandra Singer, I think you should be able to unmute yourself now. Sorry, Alexandra Stringer, if you go ahead and ask your question now. Okay.
We've got a problem there with Alexandra. You
Yeah.
have been unmuted. Oh, there we go. You go ahead.
Alexandra, you should get a pop-up. If you go ahead now.
Oh, right. Sorry, I had to. I've never used this this service before, so hopefully I've done what I need to. Yeah, so mine was just a question about, I don't think it was answered about costs. So obviously, I think there's a cost with the Public Guardian applications. How is that covered? Is there a waiver for people who are on specific means tested benefits, etc.?
Yeah, I'm happy to take that one. So costs involved in either registration of power of attorney, for example, or the costs that OPG Scotland charge. There are criteria in certain means tested benefits where you will meet fee exemption criteria and you will receive that work to be carried out for free. With the actual application, so if you've got a court application for guardianship, for example, then the Scottish Legal Aid Board will offer legal aid where there's a welfare element to the case, and also in some respects where there's a financial element to the case, again, if you meet key means tested criteria. So there is always options there. There's an application for fee exemption on our website, and there's a whole host of further information there in respect of fee exemption as well, if you wanted to have a look at that.
Okay, thank you. So it wouldn't be upfront cost and then it's claimed back or refunded, is it?
No, you would either qualify at the outset or you wouldn't qualify and you would require to pay a fee.
Okay, and sorry, I do have a second question. So there's a mention about a form that is sent to the medical professional with specific questions about mental capacity. Would I be able to see a copy of that at all? Because I'm working on a team that's looking at the appointee review process, and this is really interesting to us. So we're looking at wording, etc., of how people are appointed in terms of a DWP appointed person. So that would be really interesting if I could possibly see a copy of it just to get an idea.
Yes, if you get in touch with Amanda, Amanda will be happy to share the questions with you that's included on that form.
Right, thank you so much.
Thank you.
Okay, we have a question from Janice Sampson. If you should now get a pop-up, Janice, to unmute yourself and go ahead and ask your question. Oh, seem to have lost Janice. Okay, while Janice is sorting out her audio, if Marina Lord, if you want to ask your question now.
The first one is, yes, we see quite often letters from the OPG saying that they are unable to investigate because the adult is still capable. So when completing the form, is it clear that you'll only be able to investigate if the adult is incapable? And then if that's not the case, if the adult is still capable, in the form, do you provide any contact details of local authorities that they can refer to with their concerns?
Also happy to take that one. Yeah, so there's a few things. Obviously, some institutions and organisations won't know if the adult has capacity or not, so that which is why the first part of the OPG investigation process is to call for that medical opinion. So there's not necessarily a tick box there or a section where you complete your referral form to include information as to whether you know whether the adult's incapable or not for that particular reason. However, if you do have that information, then please do include it. And sorry, if you can just remind me of the second part of your question there.
Yes, whether, you know, if, because we do advise some of the people that contact us to raise their concerns in the form with the OPG. So is there anywhere in that form where the question is, or basically whether they explain to the person that you only investigate if they are incapable? If they believe the adult is capable, do you provide them on the form with contact details of other local authorities that they have to contact instead?
We wouldn't provide that on the form because there are over 30 local authorities in Scotland. But what is clear from our website and all the documentation round about investigations is that we only have that remit to investigate where the adult has lost capacity. We will absolutely signpost people to the appropriate local authority area. And similar to ourselves, the local authority will have their own website, and any search under adult support and protection or adult incapacity should show the adult support and protection teams for that area and the point of contact that should be used.
Okay, thank you. And my second question, if you don't mind, is in terms of how the attorneys are appointed, whether jointly or jointly and severally, and some of the documents are not clear and is left to interpretation, or having to go back to the adult or the solicitor that drew up the document. And I'm wondering whether there are any plans to maybe that in the schedule, for example, to make it easier for organizations to identify if the representatives on the document are to act jointly and severally.
Unfortunately, the drafting of a power of attorney document is not part of the remit, so we're not involved at that stage. That really depends on whoever has drafted the document on behalf of the grantor. What we can say, though, to assist is we've recently published guidance in respect of interpreting jointly and severally, which is on our website. And in fact, I think the link's been placed in the Q&A chat today as well, for you to go on and refer to if you're a little unsure when you're reading the document whether what the status is in terms of jointly and severally, particularly should one or more of the attorneys no longer be able to act.
Thank you, Fiona.
Thank you.
Okay, Janice Sampson, we'll try again. I'm just look. You should get a pop-up now asking to unmute. Yep. Hopefully you can ask your question now. Oh no, Janice, try again. Right, hopefully you can talk now. That's it.
Yeah, I just wanted to ask, you've said that we can get payments back that have been made historically, so it's important to raise an investigation quite quickly. Is that the same with POAs in England and Wales?
I think it is, but to be honest, you'd probably be better checking the OPG England and Wales website to confirm that. What I can clarify though is we don't have any authority or powers to recompensate in a power of attorney case, but we may have that option in a guardianship or intervention order case if the court has ordered cation in the case. So when we say we've got no powers to recoup, that's purely in respect of power of attorney cases and access to funds. And I do think that that's the same in England and Wales, but you would be best to check that with them.
Okay, thank you.
So we've probably got time for one more question.
Okay, Kelly Donoghue, you should be able to unmute now.
Hello.
Hi, Kelly.
Oh, brilliant. Hello, thanks, Fiona. Good to see you, and thanks a lot, Fiona, to you and your staff for doing this. I find this fascinating, and I know that you're really, really busy, and well done to you and all the guys for managing all this on a really small number of staff compared with the workload that you've got, and not to add more pressure to your day, but it'd be really great if you could do more of these sessions, because it really does have the light bulb flickering, certainly in my head. I find it really enjoyable. So thanks to everybody for your time to do this today and managing all those questions in the sidebar, including the stupid questions that I always seem to manage, including this one, which is probably just my own ignorance and trying to write and think at the same time. It's more a sort of process question to get it right in my head. When you get your power of attorney sorted and it's registered, what's the actual process? You've probably covered it, and again, it's me trying to badly multitask. When the person your power of attorney for loses capacity, do you go to the solicitor who wrote it up first, or do you go to the GP, and then is it the solicitor who lodges with yourselves to actually get something back to say, yes, this person's lost capacity and the power of attorney is now acting? Is that the process for it?
No, it's a little bit different to that. So in the power of attorney deed itself, the person who's granting the power of attorney will specify what they want their triggering clause to be, is what we would refer it to. And so that is, they will state in the document that in some instances they might say that I trust my attorneys to decide when my capacity has been lost and therefore to enact the power of attorney. In other cases it might say we would seek the medical opinion of a GP or of two medical professionals. So it really depends on what's in the actual deed itself, and the attorneys would then need to act on that. So if they then suspect that the adult in the case has lost capacity, and there is a triggering clause, for example, to get a GP's opinion on that, then they would need to organise that, go to the GP, get that on record before they can start using the powers that they've been given. So there's no need to go back to a solicitor or to come back to OPG. They can start to be used. Where we talk about obtaining that extra capacity assessment is really for an investigation. So when there's a concern being raised in respect of an attorney, we will then seek that medical opinion to ensure that we've got a locus to investigate.
Sure. So say the clause was a GP, because I think that's most of the ones that certainly we see, the GP, and the GP does that, it comes to yourselves. Is there a turnaround time for that? Because obviously if the person's lost capacity, the power of attorney wants to act quite quickly because they want to get things in place. Is that sort of a faster track than the 6 months or so to actually get the initial documents lodged, or is it another few months?
Do you mean the actual registration of the power of
so that the
attorney
person can
document?
start, so they can start to act.
Yes, so when that comes in, if there's an urgency with the power of attorney, then we gave an undertaking that we'll expedite it and register it within 5 working days.
That's great.
Where it's a routine, that's where it will sit in the queue and be dealt with in date order.
Sure, because there's obviously, once the person's lost capacity, there's usually a need to do something. That's great. No, thanks very much, Fiona. Again, thanks very much, guys. That's been excellent as usual. Thanks.
Thank you.
Can I just jump in there, sorry, just to clarify that I think in England and Wales, generally you would be waiting for sort of incapacity for registration, whereas a power of attorney document can be registered as soon as it is drawn up, so that you're not having to wait and try and get documentation in place when it's urgent. So we would always encourage an early registration so that the attorney can start to utilise their powers as soon as it's required.
Thanks, Susan. I didn't pick up on that point. Well, that's great. So I think we've ran over by a couple of minutes. So thank you all for your patience today. So moving on then, as I say, we need to stop the questions here, unfortunately, but if you do have any other questions that you would like to ask us, then please do utilise the contact information that's on the final slide today and that's previously been given to you by the team. We will share a link from today's recording and the Q&A sessions on the OPG website and the X page, so keep an eye out for that over the coming days. And I think we've also given an undertaking to share the slide pack from today with you all as well. Just to let you know, when you do leave the webinar today, you'll be prompted to complete a very short survey. So we really do hope you take the time to do this, because your feedback's invaluable and it will inform the content of future sessions. Also, to let you know, your email and contact information will be kept on a mailing list having attended today's session. If you don't wish to remain on that list after the session today, again, please pop us an email and we'll ensure to remove you from that list. And lastly, thank you all so much for attending today. We hope you've enjoyed the session and that you found it very, very useful. And we hope that from all of the OPG Scotland team, have a lovely day, and goodbye from us all.